Hello, hello, and welcome to Crime in Court. My name is Heather, and this is another crazy Delphi update. All the craziness going on in this case, I can't even stay on top of it. It was, this week it was just one thing after another at the very end of the week. The beginning of the week it was quiet, and then at the very end, they got us with a bunch of different orders. So I'm going to start, we're going to go on sequential order of, sorry, my nose itches for some reason. Somebody's thinking about me. So Judge, we're going to start, in order, or we're going to go in order. And this is, this was issued on the 21st. It got cut off on the screenshot. But Judge Gull denies more motions. Non pro tonk. I don't know how to say that. That's legal talk. But basically, I think it means without any kind of hearings or any kind of whatever. So order issued, and look at the date on it. It says 2/15/2024, but it wasn't. This order wasn't issued until the 21st of February. Order issued. Defendant's counsel motion for summary denial of the state's verified information for contemptuous conduct reviewed and denied without hearing. We went through that in my last video where the defendant's counsel wanted the whole contemptuous conduct thing just eliminated, denied by the judge. They wanted the judge to deny it. So she denies the defendant's request to deny it with no reasoning. And then also the same date, but the order's 2/15, but it's not issued until 2/21. So take of that what you will. Defendant counsel's petition for clarification regarding contempt hearing. So remember, counsel also wanted clarification on what this hearing was about. Do they need to be providing evidence? They need to know what to be prepared for. And it also would help Nick McClelland, too, because he doesn't know what, well, presumably, because it's not in any filings, he wouldn't know what this information, it's called, is for, if he's going to be providing evidence and whatnot too. So they did, it was kind of like the judge just stepped in and said, nope, I'm going to deny your petition for clarification. So you get no information on what this hearing is going to be about. So it was filed by Hennessy, reviewed. The court has scheduled a hearing on the state's pleading and therefore denies the petition without hearing. That makes no sense. So you scheduled the hearing for the state, and that's why you scheduled it. So you're not going to clarify it? That's why you deny clarifying it? Because you've already set it up for... I don't know. That doesn't make any sense to me. She's gone... She's smoking something. All right, so then the next filing that we have is the state's objection to the defendant's response of discovery. So remember, the defendant said, we don't need to give you our discovery. It's not reciprocal. We'll give you, your exhibit lists and all that, but we're not going to give you our, or not exhibit list, our witness list and whatnot, but we're not going... and exhibit list probably, but we're not going to give you all of our discovery, which is what they wanted, which is, I would say, a violation of trying to cede the court or the defendant's strategy for defending themselves in this case. I think that's what they wanted to know. All right, so anyways, the state's objection to defendant's response on discovery comes now the state of Indiana by its prosecuting attorneys Nicholas C. McClelland, and respectfully objects to any kind of continuance on discovery from the defense. So they don't even want a continuance. You don't even get more time. Screw you guys. You get nothing. No time, no clarification. You get nothing. All right, so the state would ask that the court deny a continuance on... Let me try to make this a little bit bigger here. Here. Okay, so the state would ask that the court deny a continuance of the February 21st, 2024 deadline. In support of this motion, the state of Indiana would show the court as follows. 1. The state has complied with the November 1st, 2023 deadline on discovery and continues to provide discovery as it is received. Okay, yeah. My ass. You're handing it over as you receive it. We have proof that they've been sitting on things. Number 2, the information returned by counsel to the state following their removal contained less than what had been provided. So they're saying the information by counsel to the state following the removal contained less than what had been provided, therefore requiring a complete review before it could be forwarded to substitute counsel. Are they talking about the discovery that they provided to the counsel was less? That makes no sense. Because counsel is, or for the defendant, is saying that they've received more discovery this time around. Anyways, number 3, upon reinstatement of counsel, the same information was again returned to the state, reviewed by the state, and then forwarded to present counsel. So they're talking about the discovery. Yeah, they are talking about the discovery that went from Richard Allen's defense team, who had it all categorized and organized that the way they wanted it, and then Gull threw him off the case. They had to turn all the discovery back over to the state. The state had to turn it back over to the reinstated attorneys now, and it's all out of order, and there's more things that they haven't seen, and they're still sorting through it, and they need more time, and that's what they asked for. But the state's denying that it's any different, or at first they said it's less. All right, anyway, so the state believes that all discovery in its possession has been provided to counsel. 5, the information provided after reinstatement is substantially the same as the original information. However, the state continues to supplement that information with anything new, including follow-up on tips that come in through the hotline, jail calls from the defendant, and video of the defendant at the facility where he is housed. To this date, 26 terabytes has been provided to the defense, which what? 6. It skips a page. No. It cut off. I don't know what. Oh, it's like a period there. That's their sentence. Okay. That's on Nicholas McClellan. All right, so number 7, that to date, defense has failed to reciprocate the discovery obligation with the exception of 6 names provided by the defense on February 13th, 2024, without clarification as to the witnesses' area of expertise or what they will testify to. It seems that the defense are acting in bad faith when they, at a minimum, can't identify which field of expertise their expert witnesses practice in. How is that bad faith? Because they didn't identify it? That doesn't mean that they're acting in bad faith. That the state further believes that exhibits that the defense planned to show to witnesses in the depositions should be turned over in advance of the depositions in order to prepare for said depositions. You're not supposed to prep for depositions. It's supposed to be spontaneous answers. This would assist in preparation for the deposition and would save taking breaks in the depositions to examine the exhibits. This also seems in compliance with the compromise by the state to allow the defense to take multiple depositions of the same witnesses. That the state attempted to resolve this with the defense without court intervention, but like the discovery, the defense refuses to turn over any exhibits, wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McClellan and files this objection to any kind of extension to the defense to hand over discovery. That the state would ask that the court to order the defense to turn over any and all discovery that they have in their possession immediately, along with any exhibits that they plan to use in the depositions. This is so wrong in so many ways. Yeah. Anyways, all right, so this was filed, let's see, when was that filed? I don't have the date on it. But it was the 21st also. So that came out the 21st. This came out the 22nd. This is from the defense. This is the list of witnesses and exhibits for contempt hearing. Comes now counsel for attorneys Baldwin and Rosie, and provides the following witnesses: Joe Morris, Andrew Maternowski, Kay Baylor, Mark Toma, and John Boren. Exhibits: affidavits of the following: Thomas Leatherman, Stacy Giuliani, Ashley Schultz, David Pumphrey, Andy Maternowski, James Fry, Lisa Johnson, Joel Weinecke, and Gojiko Kashish. I don't know. The Indiana. That's my very great pronunciations of all those names. You're welcome. The Indiana Public Defender Council's performance guidelines for criminal defense representation. Witness and exhibits will be supplemented as they become known. So here is our witness list. The exhibits that we're going to use refer to these people's statements or affidavits. So here you go. We gave it to you. This is the notice mailing the transcript to, meaning this motion, this filing, mailing this to all the people on here. So, and to the state of Indiana. All right, so that is, I don't know why there's two, but yeah, so that's that filing from Hennessy to the court saying, here's our witnesses. Here is, zoom in a little bit here. This is the next filing, and this came on the 22nd at 11:49, so an hour later, a little over an hour later after the defense handed over their witnesses. Here's the state's response to the defendant's motion to dismiss for destroying exculpatory evidence. So remember, there was a motion, we read that a while back. The defense said that they're claiming that some of the evidence in this case had been destroyed, mainly, specifically, the interviews of Bradley Holder and Patrick Westphal and some other characters that they had, that we read about in the Frank's memo. Those people were identified early on, they were interviewed, and those interviews have disappeared at this point. And we don't know how they were cleared so early on. Anyway, so the defense filed a motion to dismiss the charges based on the fact that there's exculpatory evidence that was destroyed, because this evidence, these interviews would be exculpatory in nature towards Richard Allen, meaning he didn't do it. So now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland, and respectfully objects to the defendant's motion to dismiss for destroying exculpatory evidence. The evidence in question is not exculpatory evidence, nor is it potentially useful evidence. The interviews of Patrick Westphal and Brad Holder are not evidence at all related to this case. So says you. You don't know. You're not the fact finder of evidence. The jury's supposed to decide that. Anyway, so the interviews of Patrick Westphal and Brad Holder are not evidence at all to this case. They are simply interviews that the defense wished to use to support a wild theory of this case that has no evidentiary support whatsoever. Actually, I would say that it does have a lot of evidentiary support so far, and the fact that these interviews have gone missing only supports the fact that there was some kind of corruption and cover-up. However, even though the interviews were not evidence, they were not destroyed by the state purposefully or in bad faith. For those reasons, the state would ask the court to deny the motion, and in support thereof states the following. that on August 10th, 2017, Carroll County Prosecutor's Office investigator Steve Mullen discovered that the DVR at the Delphi Police Department for the interview room had been recording continuously for an unknown number of days. Mullen determined that the data storage on the 6-terabyte drive had been consumed, causing the equipment to record over previous recordings, resulting in lost data. How convenient. Investigator Mullins called the company who installed the DVR immediately in an attempt to recover the information. The representative advised that all recordings prior to February 20th, 2017 were lost. Convenient again, because their interviews were within that time frame. That on February 17th, 2017, investigators interviewed Brad Holder at the Delphi Police Department. This recorded interview was lost due to the DVR recording over, as described in paragraph 1. The narrative summary prepared by investigators from that interview has been provided to the defense. 3. That on February 19th, 2017, investigators reviewed Patrick Westfall at his home and a narrative report has been provided to the defense. The report does not indicate that the interview was recorded and no recording has been located in the state's possession. Okay, well, why weren't you recording it? Why are there not body cams and things like that are being utilized here? Number 4, that the defense suggests that the state destroyed these recordings, which they believe to be evidence that is exculpatory in nature, further claiming that the loss of the recording was negligent or purposeful on part of the state. A, the interviews of Brad Holder and Patrick Westfall are neither exculpatory nor are they potentially useful evidence. I don't know how you can say that when they were the very first suspects right away. People were all pointing to them. They had tips coming in saying, hey, look at Brad Holder. Look at his Facebook posts. But anyways. B, that the state did not destroy any recordings maliciously or in bad faith. 5, the due process clause does not impose on the state an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. That's Arizona versus Youngblood. The state only has a constitutional duty to preserve materially exculpatory evidence and evidence that is potentially useful to the defense. How can that not be useful to the defense that these other people were suspects? That is evidence that might be expected to play a significant role in the suspect's defense. California versus Trombetta. Number 7, the mere possibility that a defense may have been created in the future by a piece of destroyed evidence does not mean that there was apparent exculpatory value at that time police acquired the item. The fact that evidence has an outsized significance for the defense is not enough to show a deprivation of the defendant's due process rights. Illinois versus Fisher. That the defense is merely speculating that the interviews that were recorded over will aid the defense. Mere speculation is not enough. Blanchard versus State. I think it's a little more than mere speculation at this point, but okay. Number 9, the loss of the recordings does not justify application of the 2-part test to see if the loss warrants dismissal. 10, the 2-part test consists of determining what kind of evidence is at issue and then determining if the evidence was destroyed in bad faith. So A, that step 1 is to determine what evidence is at issue. Is the evidence that is materially exculpatory or potentially useful? Land versus State. If it possesses an exculpatory nature that was apparent before the evidence was destroyed and must be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Chisel versus State. C, exculpatory evidence they wouldn't be able to get it by any other means because that time has passed. The first interview after an unaliving of someone in their community with their number 1 suspect, you can't get that back. You can't get that time back. So I would argue that is lost to them. They can't compare it to anything else because anything he says now is He's had time to think and process and lie and whatever, get his story straight. All right, so C, exculpatory evidence is a very narrow class of evidence uncovered during an investigation into a crime that tends to establish a criminal defendant's innocence. State versus Durrett. That means that it must possess an exculpatory value that was apparent before the evidence was destroyed and is such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Terry versus State. D, the exculpatory is defined as clearing or tending to clear from alleged fault or guilty accusing. Land versus State. E, the state must preserve materially exculpatory evidence, and the failure to do so deprives a defendant of due process, regardless of whether the state acted in good faith or not. Okay. How does that help? That helps the defense. In contrast, evidence is merely potentially useful if no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. I mean, it could have been. These people could have been interviewed and tests could have been taken at the time where these people, taken their DNA samples, look under their fingernails, look for injuries on their person. There could have been tests and things that could have been done if they were properly investigated that would have exonerated the defendant, but we'll never know. All right, G. If the state fails to preserve potentially useful evidence, it does not constitute a denial of due process unless the defendant can show that the state acted in bad faith. Terry versus State. The destruction of potentially useful evidence is constitutionally unproblematic absent a showing that the state acted in bad faith. Land versus State. J. The step 2 is if the evidence is considered potentially useful, determining if the state destroyed the evidence in bad faith. J. That in order to show bad faith, the defendant must show that the state failed to preserve the evidence pursuant to a conscious doing of wrong because of dishonest purpose or moral obliquity. Terry versus State. But I think that it goes to the defense's theory that there's some corruption and cover-up stuff going on here. So, I don't know. Maybe possibly even by law enforcement is, I think, the issue. So, K, bad faith requires a showing beyond simple bad judgment or negligence. It exists only if the defendant can show the state's failure to preserve the evidence was the conscious doing of wrong because of dishonest purpose or moral obliquity. That's the same thing they just said. 11. The lost recording of Brad Holder was clearly not materially exculpatory. How do we know? Even if it could be described as potentially useful, it certainly was not destroyed intentionally or in bad faith. 12. That the lack of a recording for an interview with Patrick Westphal is clearly not materially exculpatory. Even if it could be described as potentially useful, the absence of a recording was not done in bad faith on the part of law enforcement. We don't know that. Should be investigated. Further, Brad Holder and Westphal are still available to be interviewed and or deposed by the defense. But at this time, they've had so much time to change their stories. So a deposition isn't going to be as useful as the very first interview with a police or a law enforcement agent. I mean, it's not quite the same. Being deposed by a lawyer versus an interrogation from the police. A little different. All right, so the interviews of Patrick Westphal and Brad Holder are not evidence at all related to this case against Richard Allen. These interviews are part of an expansive 7-year investigation following thousands of leads selected by the defense to support a wild theory of this case that lacks a sufficient evidentiary foundation. Wherefore, the state objects to the defendant's motion to dismiss for destruction of exculpatory evidence and would ask the court to deny the same. Respectfully submitted. So, after all that, what do you guys think the judge is going to do? Well, let's take a look at her 3-minute order. The court has reviewed the accused's response to state's motion to compel discovery filed February 19th, 2024, and the state's objection to defendant's response on discovery filed February 21st, 2024. It is reasonable for defense counsel to provide the discovery requested, and the court therefore orders defense counsel to provide discovery to the state of Indiana on or before March 8th, 2024. As the state has advanced no legal authority to support its request to the court to force defense counsel to provide deposition exhibits in advance, the court will not compel defense counsel to provide such exhibits. So they're being forced to provide discovery, but not deposition exhibits. So I don't know what else that might entail that they might not want to turn over for reasons of, giving up their strategy and whatnot. All right, so counsel for defense attorneys request to allow electronics. Remember, I think it was Michael Osbrook had requested for the information hearing. He had requested that he be allowed to bring his laptop and cell phone for the purposes of if he needed to reference it. And here's her response to his request. Counsel for defense attorneys request to allow electronics at hearing filed February 15th, 2024, reviewed and denied without hearing. Counsel may contact the court executive for information regarding his request. Wow. And finally, the court, having reviewed the state's notice and request for discovery cutoff date filed February 14th, 2024, and the defendant's list of witnesses and exhibits for contempt hearing filed February 22nd, 2024, now orders counsel for the defense attorneys to provide to the state of Indiana all the exhibits intended to be introduced at the hearing on March 18th, 2024, on or before March 7th, 2024. So the hearing is the 18th of March. She's ordering everything, the discovery from counsel and the exhibits, just not the deposition exhibits apparently, but all of the exhibits for the hearing need to be turned over by March 7th and March 8th. So that's her order. If you guys haven't already thought that Gull is biased at this point, you guys have to be thinking it, right? I mean, I've been thinking it for a while, but this is just clear evidence that she gives no Fs and she does not like the defense, and she's not giving them an inch. Not an inch. She's not giving them anything. It's crazy to me that this is still going on. I don't know, as I'm not an attorney, so I don't know what Hennessy and Osbrook's next steps would be regarding throwing Gull off the case. I mean, they made their case so clear that they need a special. First of all, the contemptuous conduct was filed incorrectly. It should have been filed on a separate case, separate judge. So everything that they're doing in regards to this contemptuous conduct thing is completely out of line with the justice system. And I wonder if the Supreme Court is now regretting that they didn't kick her off the case, the Indiana Supreme Court. Well, anyways, what do you guys think? Please let me know in the comments. Don't forget to like, subscribe, and I'll see you in the next one. Thanks so much. Take care.